Invalid meeting ID, okay? Maybe I put it in wrong, but I don't think so. Do you have the docket up there
Which docket?
for today?
Yeah.
Yes?
Yes.
Read me the numbers, I'll make sure I get it right.
84657791721.
Error.
Hmm?
Hey, and Judge's mic is it on?
Okay. Is Mr. Anderson there? Oop, and you're muted. Mr. Anderson's office is muted.
There you go. Can you hear me now?
Was Mr. Anderson there?
Okay, real quick, do you check?
Can you hear me?
I'm gonna have to go, I don't know if she checked your volume or not, to be honest with you.
Is it 98?
Okay. It's on there. And if you could find out who this Naomi is.
I just need to find out who the attorneys are.
With
Your
Atkins.
Honor, my name is Robin Adkins. I'm appearing on behalf of Mr. Nelson.
There's something wrong.
Yeah, I can see people's mouths moving, but I can't hear anything.
Let me go grab Mr. Anderson. He's here with me.
Okay,
I can hear you, Your Honor. Can you hear me?
now I can.
The joys of Zoom. But I represent Mr. Nelson, Your Honor.
Right.
I was going to say I had one of those can you hear me now moments because I could hear you.
No kidding. And then Ms. Tracy, so you represent petitioner, right?
Yes, Your Honor. I'm appearing on behalf of Ms. Tracy, who's the attorney of record for Mr. Nelson, the petitioner.
All right.
Morning, Judge.
Good morning. I think we've got everybody.
Can you hear me okay?
I can hear you fine.
And if I can just get Miss Naomi's last name and who she is, I can rename her.
Okay, and so the person that's listed on the screen is Naomi. Is that Crystal Nelson?
No, Your Honor. That is Naomi Nelson. That is Mr. Nelson's wife. She is a witness here this morning.
Okay. Okay, so we have Martin Nelson, petitioner, Naomi Nelson, wife of the petitioner, and then Mr. Anderson. So do we have Crystal Nelson? Oh, okay. All right, good.
Judge, if you'll give me 2 seconds, I think they tried logging on from my computer upstairs. I'm going to have them take that one off. That way that other John Anderson is not on the judge.
Okay.
They're all. Before we get started, this registration of the foreign order has been signed, so.
Thank you, Your Honor.
All right, so I think we have everybody here. So this is cause number 2022L 8078 in the interest of Ian Nelson and Luke Nelson. Ms. Atkins, you represent the petitioner. If I can get you to introduce yourself.
Your Honor, my name is Robin Adkins. I'm appearing on behalf of the petitioner Martin Nelson. In this case, I believe we are set for special exceptions as well as a temporary orders hearing today, Your Honor.
Mr. Anderson, if you.
John Anderson here for Crystal Nelson. Respondent.
All right, so let me find the special exceptions. Ms. Atkins, if you want to state what your special exceptions are, and I'll find them in the file.
Not a problem, Your Honor. And I think for the ease of the court finding them, I believe that the most recent version of it would have been filed on the 23rd of June, Your Honor. But as far as special exceptions, Your Honor, we have 3 special exceptions that we have asserted to the 3rd amended petition of the counter petitioner in this case, Your Honor. The first one is that they have failed to state sufficient statutory grounds to modify child support as required under section 156.41 of the Texas Family Code, Your Honor. Particularly that they don't state either there's been a material and substantial change in circumstance, or that it has been 3 years since the last court order for support was put in place, and that it would be modified by either $100 or 20%. Regarding special exception number 2, Your Honor, they have failed to state sufficient information to plead that this court has jurisdiction to modify a support order that was rendered in another state, contrary to the pleadings that were currently on file by the counter petitioner in this case, Your Honor. This original order was out of Arizona. As you know, you just signed the registration order for it this morning. They haven't stated grounds that this court has the jurisdiction to modify that order pursuant to section 156.48 and section 159.611 of the Texas Family Code, Your Honor, to allow the court to actually modify that child support order. And regarding special exception number 3, Your Honor, the Texas Family Code requires that you have to plead information pursuant to section 154.181B and 154.1815, Your Honor, which is information regarding the health insurance and the dental insurance that is available for the children. Her response in this particular case in her petition just says that she will provide that information prior to the temporary orders hearing. Well, the temporary orders hearing is set for today, Your Honor, and I still don't have that information. She hasn't pled it, hasn't filed that information with the court. And so we would ask the court to require that Ms. Nelson in this case replete her pleadings to provide sufficient information to cure those defects in her pleadings for special exceptions 1 through 3, Your Honor. And that if she doesn't do so within a reasonable amount of time, that the court order that her pleadings be struck.
All right, so I think before we get to the substantive responses, are the 2 children covered by insurance, or Ian and Luke have health insurance, I guess? Do you know, Ms. Atkins?
Yes, Your Honor, they are on TRICARE through my client's employer, the United States military. And they have been since prior to the original court order out of Arizona, Your Honor.
Okay, so on that 3rd special exception, I mean, you effectively have notice of their health insurance. Is that right?
We are aware of the health insurance, Your Honor, but they haven't met the requirements of the Texas Family Code, which require that they plead that.
Okay, so then on the first 2, Mr. Anderson, about the no pleading of material change and the jurisdiction issues, what's your response to that?
Judge, I believe by them filing this action here and asking the court to acknowledge the foreign order and the court signing that we agreed that the court was going to have jurisdiction over this case, I think that renders their argument moot. I mean, this court they're asking the court to have jurisdiction over what they're pleading, but then when we plead what we want, they want to say that it's improper, that the court doesn't have jurisdiction. Excuse me 1 second, I want to find it. We acknowledge that this court has jurisdiction in this case. In fact, in their pleadings, they acknowledge that this court has jurisdiction and wants the court to decrease child support. We just want the child support to stay the same, Judge.
Your Honor, may I respond?
You may.
Thank you. Your Honor, the issue before this court regarding the special exception is whether or not their pleadings meet the burden that is required pursuant to the Texas Family Code, Your Honor. And they have to provide sufficient notice that the court, what they're claiming as far as the court having jurisdiction and statutory grounds for modifying child support, Your Honor, which would be special exception 1. They haven't stated that the court has statutory grounds to modify it. As far as jurisdiction, they haven't pled that this court does have jurisdiction. In fact, that they've pled that there is no court of continuing jurisdiction, Your Honor. And they've made some, I would hope to be typos regarding the residencies of the parties in this particular case. Particularly, Mr. Nelson does not reside within the state of Texas. As far as the court having jurisdiction in this requirement, so there is a specific requirement that they plead that the court has grounds in this. There's a specific section in the Family Code that they have failed to comply with to state that this court has the ability to do what they are asking this court to do. I'm not disputing that the court has jurisdiction, Your Honor. I'm disputing that their pleadings are not sufficient, which is why we have filed special exceptions, asking them to fix it. This is not the first time that we have filed this special exception, Your Honor. This is the first time the court has heard it. They have not remedied the situation where all we're asking for the court to do is order him to properly plead his pleadings, to provide sufficient notice of what he's asking for. And if he is believes that he has statutory grounds, to plead what those grounds are, because he has not met the burden under the Texas Family Code to either state statutory grounds, as I've pled in special exception 1, or to state that the court has jurisdiction to modify the foreign order.
Okay, and now just from what, I'll talk to Ms. Atkins for a second. From what Mr. Anderson said, he said that you're asking for a decrease in child support, and Ms. Nelson is just asking that child support stay the same. So do you see?
No,
Okay, go ahead.
that
Ms.
is incorrect, Your Honor. They are actually asking for an increase in child support.
All right, so let me go back to Mr. Anderson then. So Mr. Anderson, what is the request that you're asking for? What's the relief you want today?
Judge, we're just asking that everything stay the same. We don't believe that the pleadings are sufficient as far as the grounds that they pled as to why it should be modified under the code would not be sufficient. This is an agreed order that the parties agreed into. There's no material or substantial change in these parties or the children's lives. And so according to the code, we would, the court cannot modify this order temporarily. So we would ask temporarily that nothing change, Judge, that everything stay the way it is. And we actually are not, we're going to, after we got the discovery from opposing counsel, we're going to withdraw our increase modification.
All right, so Mr. Anderson, are you then not asking for any affirmative relief? You're just saying that petitioner's request should be denied and everything stays the same for temporary orders?
Yes, Judge. Everything should stay just the way it is, Judge.
Okay, so
Your Honor, they haven't pled anything for temporary orders at all, whether it stay the same, change. There's no relief on file from the counter petitioner in this case regarding temporary orders.
okay.
And if there would,
Okay, just wait a second, Ms. Atkins, and that's what I'm kind of getting to, is that if yeah, you have special exceptions that said you weren't given notice of their requests, but if their request is for no change, they're not asking for anything, any affirmative relief. They're just responding to your request to decrease child support. What's the notice that you would need to get from them?
Your Honor, their pleading itself, so their third amended counter petition requests an increase in child support. If they are going to withdraw that relief, Your Honor, and amend their petition, then essentially I don't need it. I don't need them to amend that if they're taking that relief away, Your Honor. But this is the very first time that I have heard that they are going to be removing their request for relief, their request to increase the child support. So if they are going to remove that affirmative relief from their request of this court, then they don't need to amend that portion, Your Honor. But until they have done so, I would ask that the court grant that special exception. And if they modify and take it out, well, then they've modified and taken it out, Your Honor. Or I should say, if they amend and take that part out, then there is no more special exception that needs to be addressed.
And so, Mr. Anderson, are you abandoning your request for a decrease in child support?
Judge, we're not asking for a decrease. I believe that was opposed. We were asking for an increase at first. Once we got the discovery, we believe it should stay the same. We do not believe that an increase is appropriate based on the evidence and the code section 156.401, which talks about grounds for modification.
Okay, well, what I just want to clarify before we get going is that, Mr. Anderson, respondent Crystal Nelson is not seeking any affirmative relief today. She's just responding to petitioner's request to decrease child support.
Yes, and we're asking that you deny all their temporary requests, Judge.
Okay. All right, so Ms. Atkins, the respondent is abandoning any affirmative relief, and we're just looking at your requests. And so other than decreasing child support, Ms. Atkins, what else are you asking for today?
Your Honor, my client is requesting that the court issue orders regarding possession and access, as well as electronic communication, and special orders for him because he is in the military to allow for his mother to be able to exercise his periods of possession when he is not available to do so because of his military duty or because he is stationed overseas, Your Honor. We are requesting a decrease in child support as stated previously. We're requesting our family wizard. And we are requesting that the court issue orders regarding the rights and duties, appointing the parties as joint managing conservators and portioning the rights as they are contained in the family code. We are also asking the court to issue orders regarding passports in this situation and long distance travel. Essentially, Your Honor, the orders, contrary to the opposing counsel's representation earlier, are not agreed orders. They were essentially what appears to be a default order out of Arizona, which I'm not sure that they are allowed to do anyway, because my client at the time was a military service member, but my client has never signed off on them, never agreed to them. They were not an agreed set of orders, Your Honor. But essentially they don't allow him any time. Except for if the two of them have agreed upon it. There are some issues regarding electronic communication. There is no set electronic communication times, no set possession and access times, and that has been an issue of contention since the divorce was granted in October of 2019, Your Honor. So essentially, we're asking the court to just give us a set of enforceable orders, rights and duties, possession and access, electronic communication, to essentially alleviate some of the stress and strife between the parties for the lack of specificity in the orders, Your Honor. And actually, once we start doing testimony, I do have a request for relief that I would like to admit into evidence. Once I call my client and I can prove that that's his request for relief.
Okay. And then I show on the docket that this is for temporary orders.
So is that also, Ms. Atkins, what you're asking for today?
It is.
Okay.
That is for our temporary orders, yes.
All right, so Ms. Atkins, what witnesses will you have?
Your Honor, I would be calling the parties and potentially Mrs. Nelson if we have time here this morning.
And Mr. Anderson?
Under oath.
I would just call Ms. Nelson and Martin Nelson, but we would ask to invoke the rule, Judge.
All right, so I can get Martin Nelson, Naomi Nelson, and Crystal Nelson to raise your right hands.
Sure.
Do you and each of you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
You do?
Okay, all right, they all said yes. And so is there anybody, since Miss Nelson is the spouse of Martin Nelson, is there anybody currently in the Zoom hearing that's subject to the rule? All right, so Miss Atkins, you may proceed.
Thank you, Your Honor. But before we proceed, how is the court ruling on the special exceptions? Are you granting them, denying them?
Since Mr. Anderson, through Crystal Nelson, is saying they're not seeking any affirmative relief, I don't see there's anything in his pleadings that that you need notice of. He's just responding to your request, asking that they be denied.
Okay. Is the court going to order him to amend his pleading to remove that relief then, to resolve the issue?
Well, I mean, he's not asking any relief.
His third amended counter petition, Your Honor, does contain a request for an increase in child support. I understand that it's on the record now, but that doesn't clean up the issue of the pleadings that are on file with the court.
Okay, so if we go to a final, and at the final, Mr. Anderson and Miss Crystal Nelson are requesting affirmative relief, then then they'll need to amend their pleadings so that any relief they're requesting for is pled correctly. But as far as today's hearing, they're not asking for anything other than defending against your pleading. So there's no special exceptions will need to be ordered today. But again, if we proceed to a final, then they would.
Okay, thank you, Your Honor.
All right. All right. So Miss Atkins, you may proceed.
Thank you, Your Honor. I would like to call Mr. Nelson to the stand.
Okay. You may proceed.
Mr. Nelson, will you please unmute yourself?
Can you hear me?
We can hear you. Can you please state your name for the court?
Martin Thomas Nelson.
Mr. Nelson, what is your relationship to Ian Nelson and Luke Nelson?
I am their father.
And what is your relationship to Miss Crystal Nelson?
She's my ex-wife.
Okay. And so you are the petitioner in this case, correct?
Yes.
And sir, do you have what has been previously marked as petitioner's exhibit 1 in front of you?
Yes, I do.
Okay, can you tell the court what that exhibit is?
It is Martin Nelson's request for relief.
So would that be your request for relief, sir?
Yes, ma'am.
Okay. And is that a summary of the relief that you're requesting from this court here today?
It is.
And do you believe all the relief that is contained within that request for relief is in your children's best interest?
I do.
Your Honor, at this time, I'd like to offer into evidence what's been marked as petitioner's exhibit 1.
So any objection to petitioners 1?
No objection, Judge.
All right, petitioners 1 is admitted.
Thank you, Your Honor. Mr. Nelson, let's do a little cleanup on some of the things I think aren't going to be a disputed issue in your case. Do you have health insurance available for your children?
I do.
Okay. And where is that health insurance provided by?
It's provided by TRICARE Prime through the
And is
military.
that, okay. And so essentially it's provided through your employer, correct?
Yes, ma'am.
And are both of your children on that health insurance?
They are.
Are any of your other family members on that health insurance?
Yes.
Okay. And would the other people that are on that health insurance include your wife and your two stepchildren?
Yes, ma'am.
Does it cost anything for you to be on that health and dental insurance as well?
Yes.
Okay. And sir, how much does it cost for you to be on the health and dental insurance?
Altogether, it's roughly about $30.
Okay. Sir, do you know whether or not it costs you any money for just you, not you and your children or your stepchildren or your wife, just for you? If you didn't have anybody else on your plan, would it cost you anything to have health and dental insurance through your employer?
Yes, it would.
Okay. Sir, I'm going to ask you to look at what's been marked as petitioner's exhibit 10. And once you've looked at that document, I'm going to ask you if that changes your testimony. Sir?
Under Exhibit 10, under TRICARE cost for active duty, single enrollment would cost $11.94. And
So, sir, I'm asking you, though, you're not included under single enrollment. You would be listed as the sponsor, correct?
correct.
Okay, and is there any cost for the sponsor?
No cost for sponsor.
Okay, so it wouldn't actually cost anything for just you to be on that plan, correct?
No, ma'am.
Okay. And it costs $31.04 for everybody else to be on your plan, correct?
Yes, ma'am.
And sir, you are still looking at petitioner's exhibit 10, correct?
Yes, ma'am.
And is that a breakdown of the cost of what it essentially costs for you to provide health and dental insurance for your family? Mr. Nelson, did you hear me?
It doesn't really break it down. It just has a flat fee of $31.04.
Okay, and but that's for your whole family for that cost, correct?
Yes, ma'am.
Okay, and so, sir, is that document that you have in front of you a true and accurate copy reflecting the cost to provide health insurance for your family, including the two children that are subject to this suit, correct?
Yes, ma'am. It is.
And you haven't made any changes to it, correct?
No, ma'am.
Your Honor, I would like to offer into evidence what's been marked as petitioner's exhibit 10.
Any objection to petitioner's 10?
No, Judge, no objection.
All right, petitioner's 10 is admitted.
And sir, I'm going to ask you to look at what's been marked as petitioner's exhibits 4, 5, and 6. Can you tell the court what those documents are?
4, 5, 6. Exhibit 4 is mine and my wife's, Naomi Nelson, tax return for 2020. 5 is my leave and earnings statement.
For what month, sir?
February, March, and April, and May
Of this year?
of this year. Yes, ma'am.
And is exhibit number 6 your 2021 tax return in W-2?
Yes, ma'am, it is.
And sir, have you made any changes to those other than to redact social security numbers?
No, ma'am.
Your Honor, I would like to offer petitioners exhibits 4, 5, and 6 into evidence.
Any objection?
Judge, no objection to 4, 5, and 6.
All right, 4, 5, and 6 are admitted.
And sir, Mr. Nelson, I'm going to ask you to look at what's been marked as petitioner's exhibit 2. Do you recognize that document?
Yes, ma'am. It's my financial information statement.
And is the information that's contained on that financial information statement true and correct to the best of your knowledge?
Yes, ma'am.
And Your Honor, I would like to offer into evidence what's been marked as petitioner's exhibit 2.
Any objection to petitioners 2?
Judge, I would object to the accuracy of petitioners 2, Judge.
Okay, do you want to
No
take it
objection
on
to
board dire on
so.
some of the accuracy?
Mr. Nelson,
Yes, sir.
when you did the wages and salary, sir, what did you base that off of?
My current LES.
So did you base that off of your LES, your Defense Finance and Accounting Service Military Leave and Earnings Statement?
Yes, sir.
Objection, Your Honor, asked and answered.
Objection's overruled.
And that was for 2022, sir?
Yes, sir.
Okay, and y'all turned over, which is number 5, petitioners 5, 4 statements. Isn't that correct, sir?
I'm sorry. Can you say it again? I'm not quite understanding.
Can you hear me okay?
Yes.
So you turned over statements for February, March, April, and May. Is that correct, sir?
Yes, sir.
Okay. And sir, do you see where it says wage year to date?
Yes, sir.
Okay, and what is that total?
Which microphone?
16739.
No. You see, under where it says under federal taxes, how much wages you made year to date. You see that, sir?
Yes, sir.
How much did you make, sir?
For which month, sir?
So year to date is for the whole year up until that point in time, correct?
Correct.
Okay, so do you see the line that says federal taxes?
Yes, I do.
Okay, on the May 2022 LES, isn't it true that it says $30,597.50 is what you've made so far as of May 31st, 2022 for the 2022 year?
Yes, sir.
Okay, so at the end of May, you had made $30,000, $30,597. Correct?
Mr. Anderson, you're breaking up.
Oh, I'm sorry, Judge. As of May 31st of this year, you had made $30,597.50, correct?
Yes, sir.
Okay, and you would agree with that May is 5 months, is that correct?
Correct.
So if you take $30,597.50 and you divide that by 5 for the 5 months to the year to date, would you agree with me that it's $6,119.50?
Judge,
don't
Your
have
Honor,
it.
calls for speculation.
Okay, well, I guess he can testify as from what he's made through May of 2022 per month. So objection as far as up through May is over.
So do you have a calculator?
I can pull one up.
Okay.
There you go.
Okay. Can you put in 30,597.5? Okay, and can you divide that by 5 for the 5 months from January to May? Okay, so now would you agree with me that $6,119.50 would be the monthly amount for 5 months that you made year to date? Sir?
Yes, sir.
Okay. So on your number 2, where you said your wages and salary per month is inaccurate, is it not? Sir?
I'm looking over the numbers.
Okay. So
Yes, sir. I would agree with you.
So, isn't it true, sir, you don't pay state tax in Texas? Correct?
Correct, sir.
Okay. So, is it true that you just pay federal tax, federal Social Security, and federal Medicare? Is that correct?
Yes, sir.
Okay. So on your May statement, your federal taxes were 308.
Mr. Anderson, we didn't hear all the question. You broke up.
Judge, do you mind if I try to move just into this other room where maybe the internet's a little better? I'm sorry, Judge. I don't know what's going on.
Okay, go ahead and try to move.
Judge, is that any better?
When you just said that, we could hear you fine. So let's see what happens.
Judge?
Yep, that sounds good. Go ahead.
So, Mr. Nelson, for the month of May, your federal taxes were $304.20. Is that correct?
Correct.
And your social security was 261.98. Is that correct?
That's correct.
Okay. And your Medicare was 61.27. Is that correct, sir?
That's correct.
So if the judge deducts just the federal income tax stuff out of your pay, and then it should be around $1,466.76 for child support. Is that correct?
Your Honor, I have to object. This goes beyond the examination regarding for poor Dyer for the purposes of proving up his financial information statement, Your Honor.
Objection sustained. Yeah, we're just trying to find out if there was something in Exhibit 2 that was inaccurate.
Well, Judge, I believe he's already testified that the wages in the petitioner's Exhibit 2 are inaccurate, Judge. So we'd ask that that exhibit not be admitted, Judge.
And Your Honor, can I redirect? I think I can clear this up.
You may.
Thank you. Mr. Nelson,
Yes, ma'am.
did you receive any type of bonus in February of 2022?
Yes, ma'am.
Okay, can you tell the court what bonus you received?
It was a select reenlistment bonus,
Okay. And how much was that bonus?
$7,500.
And why did you receive that bonus?
For reenlisting in the Navy.
Okay. And how often prior to receiving that bonus were you eligible to receive that bonus?
I'm sorry, can you restate the question?
Okay. So what is the frequency that you might be able to receive a reenlistment bonus from the military?
Twice in my career.
Okay. And have you reenlisted twice during your career?
Yes, ma'am.
Are you eligible to receive a reenlistment bonus ever again?
No, ma'am.
When was the last time you received a reenlistment bonus?
February of 2022.
Prior to February of 2022, when was the time before that that you received a reenlistment bonus?
When I reenlisted the first time.
Okay, and how many years were there in between the first reenlistment and the one in February of this year?
6 years.
Okay. Are you ever eligible to receive any other bonuses from the United States military?
No, ma'am.
So if I'm understanding you correctly, this bonus is something that you received only once every 6 years and you're never eligible to receive one ever again.
Correct.
And was that bonus taxable?
Yes.
And did you include that bonus in your wages and salary calculation?
No, I did not.
Okay. And you didn't include that because that's not something that you're going to be receiving ever again, correct?
Correct.
And so that is not part of what you would receive for your average monthly income ever again, correct?
Correct.
And Judge, we would object to that notion because it's still income, Judge. It doesn't matter if it's a bonus or not. It still goes to income for these purposes, Judge.
Well, I think it just depends if you're taking an average, if you're adding up what he made to date, and then you want to make an average, that the average may not be accurate. If in February he got 7,500, that he won't get any other months. But
Can I ask him a few questions real quick regarding just the wages, Judge?
okay, you may.
Mr. Nelson, take a look at the February LES, sir.
Yes, sir.
You said that you're not going to be getting any bonuses. However, on your LES, it says bonus owed member. So you're still owed a bonus of $5,850. Is that correct?
Yes, sir.
Okay. And what is that bonus for?
That's the same one.
Well, right underneath it, it says that that's already paid, the 7,500.
Correct.
So you've already been paid the 7,500. You're still owed 5,850.
Correct.
Okay, so that's two different bonuses, correct?
No, it's the same one.
How is it the same one when it's 7,500, you've been given that, and you're still owed 5,850?
Objection, Your Honor, asked and answered.
Objection's overruled. If you can clarify that, please do.
That's part of the select reenlistment bonus that's paid.
Well, then wouldn't it be in the select reenlistment bonus?
They'll pay it out. They pay it out once a year throughout the enlistment.
Let's
Throughout
go
their-
to March. Okay,
Okay,
you got a clothing allowance, didn't you?
correct.
You
Yes,
get
I
that
did.
every year, don't you?
Yes, I do.
Okay, that wasn't included in your wages, was it?
No,
Okay. So there are other things you get every year that you did not include in your wages, correct?
correct.
So what you put down as your wages on Exhibit 2 is not accurate, because there are things missing, and we only have 5 months worth of LESs to look through. We don't even have a whole year of LESs to look through. Isn't
Your
that
Honor,
correct?
I have to object to this being argumentative and calls for a legal conclusion regarding what is included as far as income pursuant to the Texas Family Code.
Judge, this is showing how inaccurate his wages really are, and they didn't provide us with enough information to be able to accurately depict what his wages are.
And Your Honor, may I respond?
You may.
This is the voir dire of my client regarding his financial information statement. He has stated that this is true and correct to the best of his knowledge. He has provided supporting documentation. If the opposing counsel wants to cross him on his cross-examination on the accuracy of or the contents of his income, he is more than welcome to do so. But I think that his questions have become inappropriate for the purposes of voir dire to determine whether my client has knowledge of the information that's contained on his financial information statement.
All right, so the objection is sustained, Exhibit 2 is admitted. And just for my clarification, I'm looking at this prior order from the child support end of it from Pima County, Arizona. And I know a lot of times in child support orders that we have done, there's going to be a finding of what the net income is. And is there anything like that in Arizona, or did they just come up with the amount of $1,664 a month? So Ms. Atkins, do you know if there was any finding on what the net was back in 2000?
Your Honor, I do not believe that there was any particular finding. I think that was just what Ms. Nelson had requested, which I don't know Arizona law, so I don't know if that would be consistent with Arizona's guidelines regarding this, but I do not believe that there was any particular finding that court made regarding his income previously, Your Honor.
Okay. All right, so Ms. Atkins, you may proceed.
Thank you. Mr. Nelson, you, based off of the information that you have contained and acknowledged from your LESs, you worked through a child support calculation based off of the Texas guidelines, correct?
Correct.
And that child support calculation is contained within petitioner's exhibit 3, correct?
Correct.
And the income that you used in there would not include any of your bonuses, correct?
Correct.
And would that be for the reasons that you'd previously testified to this morning?
Correct.
And you acknowledge that you received both taxable and non-taxable income when you were preparing that child support calculation, correct?
Correct.
And to the best of your knowledge, based off of the income that's contained on your LES and the way that child support should be calculated pursuant to the Texas guidelines of the state of Texas, that you believe that that is a correct calculation of what your guideline child support would be in the state of Texas, correct?
Yes, ma'am. Correct.
Your Honor, at this time, I would like to offer an evidence which is marked as petitioner's exhibit 3.
Any objection to petitioners 3?
No, Judge.
Petitioners 3 is admitted.
Now, Mr. Nelson, you have asked the court to vary from the Texas child support guidelines, correct?
Yes, ma'am.
And can you explain to the court what particularly is causing you to request that variance?
Yes, ma'am. I'm asking for a reduction because it's going to cost close to $9,000 every time I want to fly my sons out to spend time with me. And my ex wants me to pay for all those travel costs.
And pursuant to your current court orders, is there an allocation of the cost between you and Ms. Nelson?
I'm sorry, can you rephrase that?
Okay. In your current child support orders, do they state anything regarding who is responsible for any particular percentage of the travel costs for your children?
Yes.
Okay. And how much is Ms. Nelson responsible for pursuant to that court order?
39%.
And doing the math, that would mean that you are responsible for 61%, correct?
Yes, ma'am.
And you're asking that the court reduce Ms. Nelson or your child support to Ms. Nelson by the cost of 2 flights per year of her having to pay that 39%?
Yes, ma'am.
And looking at your request for relief that I'm going to, that I have in front of you, and if I can figure out how to make my computer work this morning, that I'm going to put up in front of you on the screen, you have calculated that amount in your request for relief, correct?
Yes, ma'am.
Okay. And so you're asking the court to give you essentially a credit of $583.64, correct?
Yes, ma'am.
And sir, have you had issues with Ms. Nelson in the past regarding being reimbursed for that cost of the travel for your children?
Yes, ma'am.
And sir, I'm going to show you what has been marked as, well, I'm going to ask you to look at what's been marked as Petitioner's Exhibit 11. Do you recognize this document?
Yes, ma'am.
And can you tell the court what this is?
Judge, I would object to their witness looking at exhibits during the time that they're not even admitted, and she's not privy to be going through the exhibits at the same time the witness is testifying, Judge.
And so who did you not want to see the exhibit?
Well, Miss Naomi Nelson is looking at all the exhibits at the same time as Martin is testifying, and they haven't been admitted, or they have been admitted, and she should not be looking at exhibits prior to testimony or anything like that. She should be asked about the exhibit if she's called to testify, and testify accordingly.
Okay, the objection's overruled. So Ms. Atkins, go ahead.
Thank you. Mr. Nelson, can you tell the court what Petitioner's Exhibit 11 is?
It is a summary of estimated flight cost.
Okay. And to determine those flight costs, what did you do to get an estimate of what your flight costs would be for your children in preparation of this hearing here today?
I use Google Flights, set it up for round trip, least expensive with the fewest connections between Houston and Tokyo.
Okay. And did you do them for any particular time periods?
I did for 6 months out and for 21 days in advance.
Okay. And is there a difference in the cost that you observed when searching for flights for your children between those two time periods?
Yes, ma'am.
Okay. And why did you pick a 21 days advance booking?
Because sometimes that's the only notice that I have to book flights.
Okay. And so, sir, I'm gonna ask you a couple of questions about that. You've asked this court in your request for relief for the court to order you a standard possession order, except for a variance for Christmas time. Is that correct?
Yes, ma'am.
Okay. And do you receive any particular, or should I say, do you have any particular restrictions on your time that you can take off during the Christmas holiday season?
I'm sometimes only given about 21 days of notice.
Okay. And sir, when the military is allowing their military service members to take time off during the Christmas holidays,
Mhm.
are there any particular time periods that they give you that you can essentially choose from?
Yes, ma'am.
Can you explain that to the court?
So a lot of times when they are giving leave time for holidays, they break it up between Christmas and New Year's. So I might not know if I'm going to be taking the Christmas time period or the New Year's time period. I just know a time frame between those two.
Okay. So if I'm understanding correctly, I'm going to ask some clarifying questions. Does that mean that you, generally speaking, have some time off during the Christmas holiday season?
Yes, ma'am.
And how many blocks of time does the military offer to their military service members over the Christmas holidays for them to select from?
2 blocks of time.
Okay. And then generally speaking, about how are those 2 blocks of time about 14 days based off of what you're asking the court for?
Yes, ma'am.
Okay. And do you get to pick and are always guaranteed that the one that you pick will be the time that you receive?
No, it's not always guaranteed.
Okay, but you should receive one of the 2 leave blocks, correct?
Yes, ma'am.
And would you know approximately 21 days which one of those leave blocks you would be approved for?
Yes, ma'am.
And generally, when does the military let you know when those 2 leave blocks are going to be scheduled for?
Generally, they try and let us know as far in advance as possible, but sometimes that's not always possible with the schedule, especially being forward deployed overseas.
Would it be inaccurate to say that you receive about 30 days notice generally from the military of when those leave blocks are available?
That would not be inaccurate, no.
But sir, in the past, when you've been notified more than 30 days, have you notified Ms. Nelson of that?
Yes, ma'am.
And is that why you picked the flights that were approximately 21 days out for your estimate, as well as the ones that you may know farther in advance?
Yes, ma'am.
Okay. And sir, when you were calculating the potential cost, the estimated cost for your flights, which one of those 2 numbers did you use? Did you use the 6-month booked out flights, or did you use the estimated cost of the flights that were 21 days scheduled out?
I used the 6 months out.
Okay. And would you say that that is the more conservative number of the 2 to make that estimation?
Yes, ma'am.
And sir, when you were doing those calculations, I see in front of me that there is more than one flight booked per booking per se. So that you have for one person to be able to go down there, and then you have a 3-person round trip flight. Is that correct?
Yes, ma'am.
Okay. Can you explain to the court how the logistics would work for you to be able to fly your children overseas to where you're currently stationed?
So they would need to be accompanied by an adult. So the price includes a round trip ticket for an adult and the 2 kids as well.
Okay, so walk me through this. So somebody that is living with you in Tokyo would have to fly to Houston, is that correct?
Correct.
And then that adult would pick up the children and fly them to you, or if it's you, would fly back to Tokyo, correct?
Correct.
You would exercise your period of possession, correct?
Correct.
You would return the children to Ms. Nelson in Houston, correct?
Correct.
And then that adult would have to fly back to Tokyo, correct?
Correct.
And is that what is contained within those cost estimations that are marked as Petitioner's Exhibit 11?
Yes, ma'am.
And so to your knowledge, are those a true and accurate cost estimation for the flight costs for your children?
Yes, ma'am.
Your Honor, at this time, I'd like to offer into evidence what's been marked as Petitioner's Exhibit 11.
Any objection to petitioners 11?
Yes, Judge, we would object to it as inaccurate and speculation. Those are not accurate numbers on those flights, and so we would argue that it's speculation, Judge.
Okay, well, I'll admit 11 with the understanding that it's a future prediction of flights.
Now, Mr. Nelson, I'm going to ask you, do you believe that it's in your children's best interest to have frequent access to both parents?
Yes, ma'am.
And have you had issues with Ms. Nelson in the past regarding scheduling times for you to be able to have periods of possession with your children?
Yes, ma'am.
Okay. And what would you describe the frequency of those issues with Ms. Nelson whenever you're trying to see your children would be?
Pretty much every time.
And can you explain to the court what some of the issues you have regarding being able to schedule time with your children to actually have possession of them are?
Scheduling times, figuring out how much each person is going to pay, who's going to pay what, and even issues with with my ex taking back said visitation dates, scheduled visitation dates.
Okay. Now, sir, under your current parenting plan that you have out of Arizona, are there any specific times that are listed that you're supposed to have possession of your children?
It doesn't specify, it's vague.
Okay. And so essentially you have periods of possession whenever Ms. Nelson allows you to have possession, correct?
Correct.
And has that been an issue since you got divorced with Ms. Nelson?
Yes, it has.
Okay. And essentially when you're communicating with her, this is a take it or leave it kind of situation while you're trying to reach an
Objection,
agreement on what
leaving,
you need to leave
Judge.
it.
Objection sustained.
Sir, how would you describe your discussions with Ms. Nelson regarding when you can have possession of your children?
Stressful.
Okay. And if you and Ms. Nelson do not agree on when you should have possession of your children, what happens?
I'm sorry, can you Say the question
Okay.
again.
So if you ask Ms. Nelson for possession of your children during a certain time period and she says no, what happens?
I try and I guess negotiate with her.
And if at the end of the day, she just won't agree with you and just says no to anything you ask for, do you have any ability to force the issue of when you're able to see your children?
I do not.
And so how does that make you feel when you're trying to discuss with her when you should be able to see your children?
It makes me upset. It makes me stressful. You know, I miss my boys and I want to see them.
And sir, have there ever been any times where in the period of discussing your periods of possession with your children, Ms. Nelson has essentially gotten mad at you and taken it away?
Yes.
And sir, I'm going to ask you to look at what has been marked as petitioner's exhibit 31.
Okay.
Is this an example of that kind of situation, sir?
Yes, ma'am.
And can you tell the court what petitioner's exhibit 31 is?
It is a text message thread between me and Crystal Nelson.
Okay, and can you tell the court what date that took place?
December 4th, 2020.
And is that a true and accurate conversation between you and Ms. Nelson on that day?
Yes, ma'am.
Your Honor, at this time, I'd like to offer into evidence what's been marked as petitioner's exhibit 31.
Any objection to petitioners 31?
Judge, this is incomplete as well. It's not a complete dialogue of the conversation from the days. So Judge, we'd object to the completeness of it. It doesn't give the court the proper context of what the whole conversation was about. They just took a snippet of this conversation, Judge. So we would object to the completeness of the conversation.
And do you know does Crystal Nelson have the complete conversation of that December 4th interaction?
I got a new phone.
I mean, not that. Of 2020.
Your Honor, for the purposes of making this move a little bit faster, I can offer the unredacted version of it, which it shows the conversation as of the day before, if that would help. I don't mind doing that. Would you like me to offer the unredacted version of it?
Judge, I think the problem is it doesn't show what happened on the 4th before 4:51.
And that's why I was asking if Miss Crystal Nelson has that conversation on December 4th. Back.
Not right now. We don't have the original phone. She got a new phone, so she'd have to try and even find the old phone that might have had it on there, Judge.
Okay, so Miss Atkins, do you have something that just shows like who initiated the text that had this December 4th communication, Miss Atkins?
Yes, Your Honor. And here, I'll show you up on the screen to make this This is the starting the day before of the conversation. And this is the moving into the conversation that took place on December 4th.
But, and Judge, that petitioner's 31 is different than what I have in petitioner's 31, Judge.
And Your Honor, as I've been trying to explain to the court, and I don't think my opposing counsel is understanding, this is the unredacted version of it. I have redacted it so it didn't include the December 3rd conversation, Your Honor, but if he wants this version of it to be offered into evidence, I will offer that into evidence to resolve this issue.
And I realize there's a big time difference between Houston and Tokyo. So was this one conversation that started, at least on the phone, that started on December 3rd and then proceeded into December 4th?
No, Your Honor.
Okay, so when did the December 4th text communication, what time did that start? Ms. Atkins?
Well,
The part that,
according to the exhibit, Your Honor, it started at 4:03 p.m. And the prior text message to that would have been on December 3rd at 10 a.m. the day before.
okay, and how many texts back and forth were there on December 4th, the one that started at 4:03?
Your Honor, I'm not entirely sure. This text conversation goes on for many pages. I can add them up if the court would like, though.
Well, are all those many pages part of Exhibit 31?
Yes, unfortunately, Your Honor.
All right, well, then the objection's overruled and petitioner's 31 is submitted.
Thank you.
Judge, the opposing counsel admitted that they're incomplete and that they're redacted, and they didn't turn any of that over. How are we supposed to know what was said before this if we don't have the complete conversation, Judge? And they have it in there.
Okay, the way I understand that there's a complete conversation on December 4th. There were communications before and probably after, but the unredacted conversation through text that started on December 4th at 4:03 p.m. and continued until the completion of that conversation is what's submitted.
But Judge, that's what I'm telling the court. The petitioner's 31 that they sent me starts at 4:51 p.m. It does not start at 4:03.
Your Honor, may I respond?
You may.
I sent over in my exhibits the redacted copies. However, the complete conversation, which is marked as the unredacted petitioner's exhibit 31, was produced in discovery. And she should have equal access to it. But regardless, Your Honor, an objection to incompleteness is based on their burden to provide the complete copy of the document that has been offered into evidence. And he said he doesn't have the ability to do so. I've offered it. I would ask the court to allow us to proceed.
Petitioner's 31 is admitted, so you may proceed.
Thank you, Your Honor. Mr. Nelson, is this an example of why you are asking the court to grant you a specific possession and access schedule?
Yes, ma'am.
And do you have a desire to continue to fight with Ms. Nelson about when your possession time should take place?
No.
And is that one of the reasons why you've asked the court additionally for long distance travel orders, correct?
Correct.
And where are you currently stationed? I don't think we've covered that for the record. We've hinted at it, but.
I'm stationed in Yokosuka, Japan, on board USS Rafael Peralta.
Okay. And how long are you supposed to be stationed in Japan for, sir?
For a total of 3 years.
Okay. And when will that 3 years run?
It runs until June of 2024.
Okay. And do you know where you're going to be stationed after that, sir?
I do not.
Okay. Is it possible that you may be stationed overseas again?
Yes.
Is it to your knowledge, equally likely that you might be stationed stateside?
Yes,
And have you discussed with Ms. Nelson applying for passports for your children?
I have.
And what was her response?
Objection, best evidence rule. If they have it in a text, they have. So she states it should be in the text what her response was.
Okay, I guess, Ms. Atkins, if you could just specify how this communication took place.
Not a problem. Sir, have you spoken with Ms. Nelson about this over the phone?
Yes.
Okay, and what was her response?
No.
And was there any times where she refused to discuss this with you?
Multiple times that she refused to discuss it.
Did Ms. Nelson ever provide you with a reason why she wasn't in agreement with applying for passports for the children?
No.
And sir, since you have been divorced from Ms. Nelson, have you had any periods of possession with your children?
I'm sorry, can you say again?
So since your divorce was granted, have you had any periods of possession with your children?
Yes, I have.
And what was the longest period of possession that you've had with your children since then?
About 14 days, roughly, maybe 10 days.
Okay. Was there any period of time where you had your children for a month over the Christmas holidays?
No.
Did Ms. Nelson claim that when you've tried to negotiate with her in the past regarding when you should have possession of your children?
Yes.
Sir, do you feel that you are capable of taking care of your children for a month or more at a time?
Absolutely.
Sir, how long of a flight is it between Houston and Tokyo?
I'm not positive on how long of a flight, but it's a 14-hour time difference.
Okay. And sir, if you look at petitioner's exhibit 11, does it have a time estimate on how long that flight's for?
Anywhere from 12 to 13 hours from Tokyo to Houston.
Now, sir, let's talk about electronic communication. How often would you say that you communicate with your children electronically?
I'll tell you what, we're going to take a short break here in just a second, but a couple of things I want to get clarified. So, Mr. Nelson, did I understand that you're in Japan, but you're on a ship?
Yes, sir.
So if the children came and visited you on Christmas, where would they physically be?
At my house. So I'm stationed on a ship, but it's like my place of business. That's where I go to work. I don't actually stay there 24/7.
So, I mean, every day you leave your house and go to the ship?
Correct, sir. With usually the exception of weekends.
Okay. And then one other thing I wanted to clarify, just as far as the costs, if I understand your testimony, you said someone would fly from Tokyo to Houston, pick up the kids and then return to Tokyo. Is that right?
Yes, sir.
So if I'm doing the math right, so somebody from Tokyo to Houston, that would be essentially a solo flight. That'd be one. And then if they come back from Houston to Tokyo, that'd be that person and the two kids, that'd be 3 tickets.
Yes,
and
sir.
Then return from Tokyo to Houston would be 3 tickets. And then whoever did that would be a solo ticket back from Houston to Tokyo. So that's 8 tickets that would have to be, purchased to accomplish that. Is that right?
Yes, sir.
So what's the reason, the logistical reason that you don't have somebody in Houston, fly from Houston to Tokyo with the kids and then back, that would just be 6 tickets as opposed to 8.
So currently underneath, with the COVID restrictions, they would have to be a dependent of mine or have have permission from the embassy to fly over.
So who's the person you're proposing fly from Tokyo to Houston and pick up the kids?
It would most likely be either myself or my wife, Naomi Nelson.
All right. And have you looked into the idea of the embassy approving someone? I mean, I heard earlier that you wanted your mother to exercise some possession.
Yes, sir.
Has there been some thought that your mother would pick up the kids, fly them to Tokyo, and then bring them back?
Well, if I can convince her to get the COVID-19 shot, it might be easier.
Okay. Okay. Well, let's take about a 10-minute break. So come back about 11:10.
Okay. Mr. Anderson, are you present?
They all have red. Oop, here they go. We have CPS this afternoon.
Yes.
What else do we have?
I believe that's all the CPS stuff.
All right, so we'll go back on the record on the Nelson matter and Ms. Atkins, you may continue.
Thank you, Your Honor. Mr. Nelson, has your wife, Ms. Naomi Nelson, been present at the exchange of your children when you were not at an airport since the divorce was granted?
Yes,
And how many occasions has that taken place?
2 occasions, 2 exchanges. Pick up
And
and
were there
drop
any,
off.
were there any issues at those exchanges?
No,
And do you have full confidence that your wife would take care of your children to the extent necessary to pick them up and fly them to you wherever it is that you were located at that time?
absolutely.
And did Ms. Nelson object to your wife Naomi being the person that she was surrendering your children to on those occasions?
Not that particular occasion.
Has there been words exchanged between you and Ms. Crystal Nelson of a derogatory fashion regarding your wife being the person to exchange the children in the past?
Yes,
And is one of those exchanges marked as Petitioner's Exhibit 26? You know, what? I'm going to withdraw that question and I'm going to move on. Sir, when you have electronic communication with your children, what methods do you communicate with your children through?
Facebook Messenger, we use Amazon, and sometimes FaceTime.
Okay. And do either one of your children have a cell phone?
Yes,
And which one of your 2 children has a cell phone?
Ian does.
And if you contact Ian, are you always guaranteed to be able to talk to Luke?
No,
Do you believe that it's fair to put the responsibility on Luke for you being able to communicate with Ian?
no,
And sir, do you and Luke sometimes communicate while you play video games together?
no, me and Ian do.
Okay, so it's you and Ian, not you and Luke, correct?
Correct. Yeah.
And what's the frequency of that?
Not very often. There's a big time difference between the 2 of us. Ian doesn't always get on and play. And then sometimes it's too late or too early.
Okay. And logistically speaking, if you would like to speak to your children, how do you go about being able to do so?
I text or Facebook use Facebook Messenger to Ian or to their mom.
Okay. And what type of response do you receive from Ms. Nelson typically when you contact her about being able to reach out to your children?
Usually it's I don't hear anything, and I'll just end up getting a call from them as of
Okay.
lately.
And so typically speaking, if you send a message to Ms. Nelson asking her if your children are available, what is the response that you receive?
Judge, I'm gonna object to the best evidence rule. It sounds like they're talking about text message conversation. So if they have a text message conversation that they're specifically referring to, then I believe that would be the best evidence, Judge.
Yes. I don't think right now she's asking about a specific communication, but just in general. So objections overruled unless you get into a specific conversation on a specific day.
You can answer, Mr. Nelson.
Okay, I'm sorry. Can you repeat the question?
Not a problem. In fact, we're just going to go into one specific example and make this move a little bit faster. I'm going to ask you to look at what's been marked as Petitioner's Exhibit 30.
Okay.
Is this a typical exchange between you and Ms. Nelson when you ask her if you can speak with your boys?
Yes.
And can you tell the court what Petitioner's Exhibit 30 is?
It's a text message thread between myself and Crystal Nelson.
Okay. And sir, can you tell the court what days that text message exchange took place?
December 3rd of 2020.
Okay. And sir, have you made any changes to, other than redacting your children's statements, to Petitioner's Exhibit 30?
No, ma'am.
Your Honor, I'd like to offer into evidence what's been marked as Petitioner's Exhibit 30.
Any objection to petitioner's 30?
Judge, the same objection as I had before. It's a incomplete message. We would object on incompleteness, Judge.
So objection will be overruled, and will exhibit, the part of Exhibit 30 that will be admitted is that specific conversation with a beginning time and an end time.
Mr. Nelson, what was your purpose of communicating to Ms. Crystal Nelson on December 3rd of 2022?
Oh, I wanted to call and talk to my boys and tell them good night.
Okay. And do you consider your reaching out to her through this text message to be demanding?
No,
When you sent this to her, were you making any attempt that you thought that she had to let you speak to your children right then?
no.
And is this the typical of the attitude that you receive with Ms. Nelson when you're trying to communicate with her regarding your children?
Yes.
And how would you describe this Ms. Nelson's attitude in this text message exchange?
Angry, irrational. Pretty much, yeah, angry and irrational. And belittling.
Okay. And sir, what do you think the solution is to stop the back and forth between you and Ms. Nelson regarding when you speak with your children, as far as days and times?
I think the least amount of communication that we have with one another will alleviate any sort of arguments. And I believe the best foot going forward for that would be to use a good parenting app.
Okay. And is that why you've asked this court to order that the two of you communicate through our family wizard?
Yes, ma'am.
And do you believe that the court granting the relief that you've requested regarding electronic communication in your request for relief that's been marked and admitted as Exhibit 1 would resolve a lot of the back and forth between you and Ms. Nelson regarding when, as far as dates and times, that you would have the right to communicate with your children?
Yes, ma'am.
And sir, has Ms. Nelson ever made representations to you that she considered you communicating with her and attempting to communicate with your children to be a disruption in her life?
Yes.
And based off of the communications that you've had with Ms. Nelson, do you believe that she is resentful that she has to communicate with you at all?
Speculation, Judge, as to how Ms. Nelson feels about this.
Objection sustained.
Sir, when you have possession of your children since the divorce, what is the frequency of communication that you allow Ms. Nelson to have?
As much as she wants.
Okay. Has there ever been an occasion where she's contacted you while you're in possession of the children and you've refused to allow her to communicate with them?
No.
And And sir, have there been numerous conversations between you and Ms. Nelson since you've gotten divorced regarding scheduling times for you to communicate with your children?
Yes.
And what adjective would you use to describe those conversations?
I'm sorry, can you rephrase?
So you've testified that you and Ms. Nelson have had numerous conversations regarding scheduling times for you to speak with your children, correct?
Correct.
What adjective would you use to describe those conversations?
This is embarrassing, but can you tell me what adjectives are?
So it's a descriptive word. So for example, angry, hostile, a
Objection,
descriptive word.
leading judge.
Yeah, objection sustained. But just describe what her attitude is.
All right, thank you, sir. It's her attitude is very off-putting. She comes off as being annoyed and interrupted, hostile. She's belittling to me and my family.
And sir, have you ever reached an agreement with her on when you would have consistent phone time with your children as far as days and times of the week?
No, I have not.
Okay. And would you consider your situation that you have regarding your possession and access similar to what you have regarding your electronic communication as it is to, if you don't agree with Ms. Nelson, either you agree or you don't get anything?
Correct.
Objection, leading judge.
Objection overruled.
And so right now, who would you say has complete control over when you have any type of possession or access to your children?
Miss Crystal Nelson does.
And in your opinion, do you believe that Ms. Nelson wants you to have close and frequent communication with your children?
No.
Is that what you're looking for here today?
Yes.
Sir, has Ms. Nelson, outside of when you've had possession of your children, has Ms. Nelson ever reached out to your mother to have possession of your children since you've been divorced?
Yes.
And to your knowledge, has your mother ever had possession of either one of your two children at Ms. Nelson's request?
Yes.
And where does your mother live?
In Greenbrier, Arkansas.
And sir, I'm going to show you what's been marked as petitioners, or I'm going to ask you to look at, excuse me, petitioners exhibit 20.
Okay. I think I have it up.
Okay. Can you tell the court what that document is?
It is a Facebook Messenger thread between Crystal Nelson and myself.
Okay. And what days did that conversation take place on?
April 2nd of 2022.
Does it only include April 2nd of 2022, or is there more days included in that conversation?
It starts from March 31st, 2022 and ends on April 2nd, 2022.
Okay. And is that a true and accurate conversation between you and Ms. Nelson between March 31st of 2022 and April 2nd of 2022?
Yes, ma'am, it is.
Your Honor, I would like to offer what's been marked as petitioners exhibit 20 into evidence.
All right, any objection to petitioners 20?
No objection, Judge.
All right, petitioners 20 is admitted.
And sir, is this the conversation you had with Ms. Nelson regarding your mother having possession of one of your children?
Yes, ma'am, it is.
And did that period of possession take place?
Yes, it did.
And was there any issues whatsoever?
No issues.
And did your mother at that time have one or both of your children?
Just one.
Okay. And do you know why she didn't have both?
This time frame, Ian was in school.
And do you believe, because, and you've testified to this previously, that it's in your children's best interest for your mom to be able to exercise some of your periods of possession when you are deployed on military duty or you're stationed overseas?
Yes, ma'am.
And have your parents attempted to reach out to Ms. Nelson to have communication with the children while she
Yes,
has
they have.
possession of them?
Yes, they have.
Okay. And have you ever discussed that with Ms. Nelson?
Yes, I have.
And what was Ms. Nelson's response when you attempted to discuss that with her?
She told me that if they wanted communication with the boys, they needed to do it on my communication time.
And so is that something that poses some difficulty?
Yes.
And do you believe that it's in your children's best interest for them to be able to have more frequent communication with your family members?
Yes, I do.
And do you believe that your mother being able to exercise some of your periods of possession while you're stationed overseas and can't exercise, for example, a first, third, or fifth weekend because of the flight times, would be in your children's best interest?
Yes, ma'am.
Now, sir, have you run into any difficulties with Ms. Nelson interfering with your conversations with your children when you're speaking with them?
Yes, I have.
Okay, can you please explain what those difficulties are?
She will take the phone from them and start talking to me about parenting matters in front of them. She will end the conversation mid-conversation.
Okay,
And a lot of the times the electronic communications, the phones aren't sufficiently charged, so the conversation ends abruptly.
okay. And sir, have you ever made any recordings of Ms. Nelson interfering with your phone calls with your children?
Yes, I have.
And is Ms. Nelson aware that you've made these recordings?
Yes.
And sir, have you attempted to address that you don't think it's okay for her to have these discussions with your children present?
Yes, I have. Numerous times.
And what has been her response?
She disregards what I request.
And sir, I'm going to ask you, have you reviewed what's been marked as petitioner's exhibit 14?
That's the audio recording.
Yes, sir.
Yeah. Yes, I have.
Did you take that audio recording, sir?
Yes, I did.
And was that an audio recording that you took on December 5th of 2020?
Yes, it is.
And do you recognize Ms. Nelson's voice on that audio recording?
I do.
And have you made any edits to this audio recording at all?
I have not.
So is this a true and accurate copy of the audio recording that you took of your conversation with Ms. Nelson on December 5th of 2020?
Yes, it is.
Your Honor, I'd like to offer into evidence what's been marked as petitioner's exhibit 14.
No objection, Judge.
Okay, petitioner's 14 is submitted.
And Your Honor, I'm going to play this exhibit and I'm going to ask the court, if you can't hear it, to let me know.
All right.
Probably helps if I share the screen to do this properly.
He called me. I didn't call him.
Is it on?
Hello.
I don't know why it's not on. Video on. There it goes. Okay.
Are you emailing? Look, I need to talk to you privately.
I thought you wanted the correspondence through email.
Can you hear me?
Can you hear me? Can you hear me?
Yeah.
Okay.
I need to talk to you privately.
Okay, I thought you wanted the correspondence by email.
Yeah, but Ian's here and Ian doesn't have an email address, but you're taking your evasive whatever and not responding to what I'm saying. I need to speak with you privately.
Hey, Bubba.
Hello. Mommy's not trying to steal me from you.
Bubba, I didn't say mommy's trying to steal you from me.
Did you say that I'm trying to prevent a relationship?
Hey, whoa, no. We're not. This is a conversation for you and me, not.
Are you alone? Then why are you still have other people in the room with you?
What?
Why do you have other people in the room with you?
I don't have anyone in the room with me.
Then show me the room.
I don't need to show you the room. And then also, this is not a conversation. This,
Do you have a copy of, no, Ian wanted to call you and tell you what's going on. Because every time I tell you what he tells me, you
Hey,
call me a liar.
if Ian wants to, if he wants to talk to me, then he can talk to me. I don't need to talk to him through you.
I know, and he's gonna do that, but I also have things to say.
Well, then we can have that offline. We can, hey, are you gonna let me talk?
No.
Okay,
Here's the thing.
no,
In your last
hey,
in your last
email me. Any correspondence you want with me, just email.
I'm not emailing you anymore. That's what I'm telling you. Do you have a copy of the court order?
Not in my hand.
Do you
Hey,
have a copy of it, or do you need me to
first
send you a
off,
copy?
any conversation you have with me right now does not need to have any of the kids involved. Right now,
Do you have a
do you hear
copy
me?
of the court order?
If you want to talk to me about it, talk to me without the kids around.
You're not going to control me.
I'm not controlling you. I'm telling you not to.
You are-
You're involving the kids in this, and this is uncalled for. Uncalled for right now.
Answer my question.
No, if you want to talk to me, you'll talk to me when the kids aren't around. You are not involving our kids in this.
You are involving our kids in this.
No, I am not.
Yes, you are. Whenever you say that, whenever I tell you what they tell me, and you call me names and call me a liar and all this stuff.
I didn't call you a liar. I didn't call you any
Yes,
names.
You did. Yes, you did. You did, and you always do. You're always mean to me. You accuse me of having evasive action and trying to keep you from the kids. And I have done nothing. I have given you every request that I let them come stay with you during COVID. I let you have all this. And what do? You just keep coming at me.
You can talk to me about this when the kids aren't around.
No.
Sir, is this the only phone call that you've had with Ms. Nelson that has ended similar to this?
No, it's not the only one.
And so do you believe that having that type of conversation in front of your kids is in your children's best interest?
No, I do not believe so.
And have you ever called her a liar?
No.
And sir, is this why you're asking the court to order that you and Ms. Nelson communicate exclusively through our family wizard?
Yes, it is.
Okay. And sir, I'm going to show you a portion of what's been marked as petitioner's exhibit 16. And well, after I've admitted into evidence. So do you recognize the audio recording that's been marked as petitioner's exhibit 16?
Yes, ma'am.
Okay. And was that a communication between you and Ms. Nelson?
Yes, it is.
And sir, is that a true and accurate copy of that communication?
Yes, it is.
And for the purposes of moving forward as far as evidence here today, we're only going to be showing a portion of that communication to the court today, but the full audio recording we are offering in evidence, correct?
Yes.
Your Honor, at this time, I'd like to offer into evidence what's been marked as petitioner's exhibit 16.
Judge, we would object. That's never been produced to my office.
So has that been produced in discovery, Ms. Atkins?
It's been produced in discovery and it was also sent over via Dropbox link pursuant to the court reporter's instructions on the 23rd of June, Your Honor.
Judge, I don't know what happened with the link, but that was not on the link. And I do not have any of that in the discovery. I have all the discovery here, and opposing counsel said earlier that the discovery was sent and with those text messages. That was not sent. Neither has this.
And Your Honor, petitioner's exhibit 16 was sent with not the first supplemental, but the original initial disclosures, which were sent on the 13th of May. But regardless of that, Your Honor, they were sent in a Dropbox link on the 23rd. And I know that they were because we had an issue with the court reporter being able to open them because of the format on her computer. So we had to send them again the very next morning because of a formatting issue. So I'm 100% positive they've been sent, and they were sent last week, in addition to them being sent in May, Your Honor.
I withdraw my objection. I'm sorry. It was 17 that was not
Okay.
listed.
All right,
I'm
so-
sorry. 16 was.
So petitioner 16 will be admitted, and Ms. Atkins, how much more testimony do you anticipate?
Your Honor, I'm about wrapping up his testimony, and I would just like to admit a couple of exhibits through Ms. Nelson. Unfortunately, because she's included in the conversation, in order to admit those exhibits, she's going to have to prove them up unless the opposing counsel would be willing to stipulate to those admission. I've attempted to communicate with him about stipulating, and I haven't received a response.
Well, it was through a chat this morning, Judge, and I didn't see it till after we were halfway through here. What exhibits are you wanting to stipulate to, Ms. Atkins?
I would like to stipulate to the admission of 42, 43, 44, 45, and 46 and 47, and 48.
So 42 to 48.
Yes, and if I can do that, Your Honor, then I wouldn't need to call Ms. Nelson as a witness.
Judge, while she's continuing on, I will look at those. See if we're agreeable to stipulate.
Okay, you can look at that. I'm wondering, time-wise, what we're going to do. I have some contested hearings starting at 1:30 that'll probably take a couple hours. So we can continue for a little bit, but if we come back this afternoon, it's going to probably be after 3 o'clock. So I just don't know how that fits in. I know we're talking about schedules all over the world here. So, but anyway, Ms. Atkins, if you want to go ahead.
Thank you. And
He doesn't mean to encourage you to do stuff. It's not. Yes. Did he tell you it was time for bed? No. Then he's encouraging you. He's not encouraging me. I just said go to bed.
Hey,
Hey, you need to get off of type at 7:30.
I'm not telling him to stay on. In fact, I was talking. Hey, wait, hold on. No, you don't, because I can hear you. I can hear you talking to him through the
I
headset,
need you to tell him to get off.
and you're like,
Are you listening to me?
no, let me speak, please.
Oh my God, you're not speaking to me.
I
You're
didn't-
Speaking out of your mouth.
No, I'm not. I was telling Luke
Come on.
to go eat, to go. And I was telling him bye. And I said, give the headset to Ian so that I could tell Ian the same thing.
Ian is eating dinner.
Well, yeah, he is now, but I was trying to tell Ian to go listen.
To go eat dinner for the last 20 minutes.
Well, all you have to do is tell him.
I have been telling him. And just like I told him, we have to start getting ready for bed. But I'm playing with Daddy.
And I tell him that he needs to do as you ask.
I know, but he doesn't understand. It isn't. Look. Tech time is over at
It's-
7:30.
That's good. Set that rule with him. That's all you have to
Okay,
do.
but I need you to support that. So
Of
at,
course
like,
I support that, but-
7:45, you need to be like, hey, Ian, we have to get off in 5 minutes or whatever.
I mean, I do support that.
I'm not trying to say that you don't, but I'm saying moving forward, you need to. Because I know that you didn't tell them to get off at 7:25 today.
You're there. I'm here.
I know, but you're on the thing with them.
Oh, I thought you were just letting me talk to them because you said you said you're gonna have them call me.
I was. Because it's the same thing as you calling in anyway.
I know, that's why I was talking
Just
to
like you
Luke.
talked to them yesterday. I don't want to sit here and talk to you. I don't want to sit here and argue with you. All I need you to do is understand that at 7:25, he needs to start getting off the thing and he needs to be off by 7:30. Because we have a life and things that we have to do. And we can't play with video games with daddy every day.
Did you make that clear to Ian before?
Yeah. This is the same conversation that we had in Phoenix
You-
before I
did-
left.
Well, why?
This is
Well,
the same fight that we had whenever you called and said that you weren't getting enough time with them, even though you were playing video games with them multiple times a week.
it's not. No, that wasn't.
Just
It
moving
wasn't.
forward,
Don't-
I
you-
need you to understand moving forward that bedtime is 8 o'clock. So tech time ends at 7:30. So you need to support that by starting to get them off by between 7:20 and 7:25. It makes sense, right?
Yeah, it does make sense.
Okay, that's it. Did you send the form over?
No, I did.
Sir, I know that this is hard for you to, just looking at your face, I can see that this is hard for you to listen to.
Objection, testifying and leading.
Objection sustained.
Sir, is this typical of kind of the interference that you received from Ms. Nelson?
Yes, ma'am.
And have there, other than the audio recording that we played, has there been other times where she has prevented you from being able to say goodnight to the children?
Yes, ma'am.
And so do you think that if you had a guaranteed amount of time to communicate with your children, that you would be able to finish up and tell them goodnight before you got off the phone?
Yes, ma'am.
And is that why you're asking for 15 minutes with each child in your request for relief?
Yes, ma'am.
Sir, do you think that there is anything else this court needs to know before we go to a different witness this morning?
Just that the reason why I'm here today is because I want more time with my boys, and I would like the court to clarify that time so that I don't have to argue with my ex anymore. And under the current order that we have, it's vague and it leaves room for interpretation.
And is one of those things for interpretation the amount of the cost of the flight travel?
Yes,
And in your opinion, has she paid you the full amount of the flight travel that you have, that you're entitled to?
no,
Is that one of the reasons you're asking for the reduction in the child support?
yes, ma'am.
Your Honor, I pass this witness.
All right, yeah, before we start with Mr. Anderson, what's the schedule looking like? Can people come back at 3 o'clock Texas time?
Judge, I just don't know that that's enough time. I mean, we're not even through with this witness yet. And
Well, and it may not be enough time. I'm just trying to, when we can continue.
Your Honor, I'm available at 3 o'clock. I'm trying to do the mental math in my head to see what time that would be for my client. Mr. Nelson, does that work for you?
It's about 3 hours from now.
3 hours from now. I can make it work.
All right, and so, and Mr. Anderson, and again, I'll have you start up some of your cross, but then we'll have to recess and continue later this afternoon.
Judge, I'll have to move some stuff around. I had a bunch of meetings confirmed and people coming in to meet with me this afternoon that I had scheduled for a couple of weeks ago, but I can do some calling while we're out and see if I can't move some of them.
Okay. And we will have to send out another Zoom link also. But so, Mr. Anderson, why don't you get started now and let's see how far we can go.
Judge, what time are you thinking about calling it? That way I know kind of where to.
Well, I mean, probably give you about 10, 15 minutes right now, and then we'll need to take a break.
No, that's fine, Judge. I just didn't want to, I didn't want to get in something lengthy. Mr. Nelson, you had talked about your mom doing some visitation, and Crystal is, even as far as this past, was it March or April, she gave your mom a week with one of the boys?
Yes, it was in April.
It was in April? Okay. And she agreed to let your mom have the child for a week?
Yes, sir.
Okay. And you're requesting that the court give your mom some custody in lieu of you. Is that correct?
Correct.
Okay. And would that visitation, how does that look to you? Does it look like one weekend every quarter that the kids can go for a long weekend up there for every quarter of the year and then for a couple weeks in the summer?
Objection, Your Honor. That's asked and answered. He already testified. It's contained in his request for relief.
Objection's overruled.
You can answer, sir.
Oh, thank you. Yes, sir.
So you'd be happy with that if your mom got to see the kids that much?
Yes, sir.
Okay. Would your mom be willing to come pick them up from Miss Nelson's residence?
She has already. Yes.
Okay. So if the court was to give her a visitation and order her to come to Miss Nelson's residence to start that visitation, your testimony is she would be okay with that, correct?
Correct.
Okay. Sir, you chose Japan as a duty station, isn't that correct?
No, sir.
So how did the duty station, did you re-enlist to get the duty station?
No, sir.
Did you put your top 3 choices to get your duty station?
Objection, Your Honor. Relevance.
Okay. Objection's overruled.
No,
Did you
sir.
give the Navy your top 3 choices of where you wanted to go when you re-enlist?
No.
So how did Japan become your duty station?
My ship was home port shifted from San Diego to Japan before I got orders there.
Okay, did you pick to go to San Diego?
Yes.
So you chose to go to San Diego and then it just happened they changed the duty station to Japan?
Correct.
Sir, did you look up the travel advisory from the DOD?
For what?
Have you ever looked at the travel advisories that the DOD puts out?
Yes.
So you're aware that there are different levels, correct?
Correct.
Level 1 to level 4, correct?
Correct.
Level 1 being like a mild restriction, level 4 being do not travel, correct?
Correct.
Level 3 being reconsider travel, correct?
Correct.
And you're aware of all these, correct?
Yes, I am.
And Japan is actually a level 3, is it not?
I don't know if it's still currently that.
Okay. As of April of 2022, it was a level 3, correct?
Correct.
Which is reconsider travel, correct?
Correct.
Which is why you testified earlier that you have to even apply through the embassy in order to be able to even travel in, and you have to be a dependent of yours to travel, correct?
Somewhat, yeah.
So in order to even come, they have to go through the embassy. Is that correct?
No,
You stated earlier in your testimony you had to apply through the embassy for them to come.
that's for certain family members and friends.
Okay. And your kids are your family members, correct?
They are my immediate family members.
Okay. So would that be, you would have to go through the embassy?
No, sir, they're SOFA sponsored.
Okay. But there's a level 3 because of the rampant COVID, correct?
Correct,
Objection, Your Honor, speculation.
Well, objections overruled. He could testify if he knows.
Correct.
correct.
Which is why you stated earlier that your mom wouldn't get a vaccine, so she can't bring them, right?
Mm-hmm. I was joking. Yeah.
You have to say yes or no, sir.
Oh, okay. Yes.
Okay. And you're also aware of the Ukraine-Russia incident that's over there, correct?
Yes.
Objection, Your Honor, relevance.
Objections overruled.
And that China is also anticipating stuff. And so Japan is going on the defensive right now. Is that correct?
Objection, Your Honor, relevance.
Okay, objections overruled.
I don't know.
Have you been doing training to prepare in case China mobilizes?
We're always doing trainings.
Okay, but specifically, are y'all doing trainings in case China mobilizes against Japan?
Your Honor, I have to object to the relevance of this line of testimony regarding this particular custody case.
Okay, if part of the request is that the two children get to go to Japan, I think it's relevant to find out the safety of Japan. So objections overruled.
We are training to oppose any foreign threat to the United States government.
And specifically, China is right there by Japan, is it not?
That is geographically correct.
Okay. And so you're the first line of defense for the U.S. if China does something, correct?
Possibly.
Okay.
There are other forces.
Okay. And so not only is it a level 3 reconsider travel because of COVID, but there's also things going on geographically near you in Japan, correct?
Objection, Your Honor, vague and compound.
All right, why don't you restate your question?
Yes, Judge. There are military threats that are currently geographically close to Japan that could jeopardize your kids' safety and well-being.
There are military threats that could jeopardize my kids' safety all over the world. Doesn't matter where they're at.
Okay. But they are not Japanese citizens, are they?
No, they're not.
They don't live in Japan normally, do they?
No, they do not.
Okay. And how quickly do you have to report to your duty station if something happens?
Within 24 hours, usually.
Okay. So within 24 hours, you have to be at your duty station and you cannot protect these boys, correct? If something was to happen.
I would not be in their presence, no.
Okay. And if they get COVID-19 while they're over there, isn't it also true they have to quarantine
Yes.
for 14 days before they can return?
No, sir.
How long do they have to quarantine, sir?
Minimum's 5 days.
So at least 5 days they'd be in quarantine
Correct.
before they could board a plane.
Under my understanding of the current guidelines, yes.
So since the divorce, you stated that you have only had possession of the kids for about 14 days.
Correct.
Objection, Your Honor, misstates testimony.
Objection's overruled.
And where did you have possession of those children for 14 days?
I had them over the Christmas break recently in Arkansas. I believe it was actually less than 14 days, but it was from December 29th until January 10th or 11th.
Okay. So yeah, that was about 14 days. Right?
Mm-hmm.
You have to say yes or no. She can't take uh-huhs and uhs.
Sorry. Yes.
Now, earlier, you said sometimes you get 21 days notice or 30 days notice before Christmas leave. Is that correct?
Correct.
Now, is that leave that counts against your, so in the military, you acquire leave days per month, correct?
Yes, sir.
Is it still 1.5 days per month?
No, sir. It's
What is
2.5.
2.5 days per month.
Correct.
Okay. So that Christmas leave that you're talking about, is that you having to put in for leave, or do you just automatically get that from your company?
I have to put in for it.
So it counts against your leave that you accrue?
Correct.
Isn't it true that you can put that in whenever you want?
Yes.
So you could put that in September that you want them in for Christmas, correct?
Yes.
And as long as it gets approved, then you're fine, right?
If it gets approved, yes.
Okay, so it's not necessarily you only get 21 days notice sometime. If you're not proactive, you don't get notice sometimes till 21 days, but you can put in for it way in advance, correct?
Correct.
Okay. Now, your counsel and you presented some estimated flights, correct?
Correct.
Now, you're asking that the child support be reduced to a certain amount because of these flight costs, correct?
Correct.
But like your bonuses, these flights only happen maybe one time a year, and it's not going to happen forever, correct?
Objection, argumentative.
Objection's overruled.
In fact, it's only going to happen one time while you're stationed there if the judge allows it, correct?
While I'm stationed in Japan, possibly.
Yeah.
It may.
Okay. So you're asking, though, for a reduction in child support based on something that could potentially happen one time, but she's supposed to live with that reduction until the boys are 18? Is that what you're asking this court?
Objection, Your Honor, calls for speculation.
Okay. Objection's overruled just as far as what his request is.
No, that is not correct.
Well, that's what you presented to the court with your request, is that you want her child support to be reduced to a certain number, a set number, based on these flights. But yet that's only going to happen one time, correct?
Objection, Your Honor, asked and answered.
Objection's overruled.
You can.
No, sir, not correct.
So how many times potentially could the boys fly out if the judge was to allow?
They could fly out up to 2 times while I'm stationed here in Japan from my current PRD.
But you don't know where you're going next if you go somewhere at all, do you?
No, I do not.
Okay, so to set her child support based off Tokyo flights would be improper now, wouldn't it?
No.
But it is improper to add your clothing allowance that you get every year. That's what you're telling the court?
That is improper.
Objection, Your
Yes.
Honor, argumentative.
Objection's overruled.
Now, is it fair to say that y'all didn't get along early on?
Objection,
Yeah.
Your Honor. Can I get a time frame?
Objection sustained.
So right after y'all got divorced, there was some tension, correct?
Correct.
But Crystal works with your mom as of April, correct?
As of April, yes.
And she actually talked to your current wife, Naomi. Is that true?
Correct.
Okay. And tried to go through her to communicate. Isn't that true?
Correct.
To try and resolve some of that hostility, correct?
Correct.
And you're at work, and does Naomi stay at home?
No.
So Naomi works there in Tokyo as well?
No.
Where does she work at?
She just started working with Fleet and Family Support.
So is that on base as well?
That is on base, correct.
Okay. And I'm sorry, where are you stationed at exactly in Japan?
Yokosuka,
Yokosuka, and where is that at?
it's south of Tokyo.
So if a flight comes into Tokyo, you have to take another plane to get to where you're at?
No, sir.
You drive?
Correct.
How far is the drive?
About 1 hour.
So if something was to break out over there, Naomi would have to drive your boys to the airport an hour because you'd be gone, and then try and get the boys out.
Objection, Your Honor, as to speculation and as to vagueness, as to if something breaks out.
Objection sustained.
So if a conflict happened and you got called in, are you telling the court that Naomi would have to drive an hour with your boys to get them to an airport to get them back home?
Speculation.
No.
Your Honor, objection. This calls for speculation.
Objection's overruled.
No.
Sir, isn't it true that y'all had agreed to telephone communication on Saturdays?
Yes.
So you and Crystal had an agreement to talk with the boys on Saturdays, right? So
Correct. On Saturday.
And so on (12/3 of 2020, that wasn't a Saturday, was it?
I don't have a calendar in front of me.
Okay. If I was to tell you that it was a Thursday, would you, by looking at a calendar?
I would have to take your word for it.
So if I showed you that calendar,
Your Honor, I have to object here. The witness is only allowed to testify to what he has personal knowledge of, and he's answered the question.
What, in 2020, what month are you talking about?
December 3rd, Judge. Judge, we'll have the court take judicial notice of a calendar dated December 3rd, 2020.
I'll just take judicial notice. December 3rd, 2020 was a Thursday.
Okay. So that wasn't a Saturday, was it?
No, it was not.
Okay. And y'all had agreed to talk on Saturdays, yet you texted her and said, can you have the boys call me right now? Right?
Correct.
And that was at 7:22. And was that Arizona time? What time was that?
Can I get reference what exhibit you're looking at?
30, y'all's 30.
This is 7:22 PM. I believe that's Central Time.
Okay. All right. And she simply tells you she's at Walmart, right?
Correct.
Okay. But then she also asks you why you need him to call right then, right?
No,
She doesn't say why?
it does say why.
Okay. Then you go to 7:32 and she tells you when you're demanding, I assume there is an emergency, right? You see that where she says that?
Yes.
So that's why she asked you why they needed to call, because she thought there was an emergency, right?
I don't know what her frame of mind was.
Well, she's telling you right there in that text. She assumed it was an emergency.
Objection, Your Honor. Best evidence. The document speaks for itself.
Okay.
We'll just consider exhibit 30.
Now, let's turn to number 20.
And is this kind of going down a different trail of questioning, Mr. Anderson?
Well, it's more about text messages, but Judge, we can stop if you want. It's not a problem.
Okay, so why don't let's break and we'll plan on coming back about 3 p.m. Texas time, and a new Zoom link will be sent out to everybody. So you're all
Your
excused.
Honor, just as a cleanup matter, so that way I don't have to have Ms. Nelson, or excuse me, Mrs. Nelson come back. Counselor, are you willing to stipulate to those exhibits or no?
So 42, 43, 44, and 45. I can stipulate to, but 46, 47, 48, that there's hearsay in that. It's incomplete. It barely even states anything in some of those. So we would object to 46, 47, 48.
That answers my question. Your Honor, I'd offer then 42 through 45 into evidence. And I will have to call Mrs. Nelson back at 3 o'clock.
Okay, well, at 3 o'clock, we're going to continue the cross-examination. I would anticipate that's going to go a couple hours, since I think Miss Atkins, you had about a couple hours of direct. So we're just gonna have to see how much we can get done today. But 42, 43, 44, 45 are admitted, and we'll be in recess till about 3, and that's going to be dependent on how soon I get those other cases completed. So if people can be ready at 3. You're all excused now.
Thank you, Judge.
Thank you, Your Honor.
You have a list of exhibits,
I just have it on the docket sheet.
right? I don't have a for sure about plaintiff 26 or plaintiff 16. I wrote them down because I don't see where I marked that it was anything.
I have 16 was one of those audios, the calls. So that one I do have. What was the other one?
It was admitted.
Yes.
Okay, so that's admitted, and then P26.
26. Let me see. So I got. I can't tell. Okay, so I got 10, 4, 5, 6, 2, 3, 11, 31, 30, 20, 14, and 16.
Okay, what
And-
about P1? That was the first one I got.
Oh, yeah, I'm sorry, P1.
Okay, I'll leave it at that.
And then 42, 43, 44,
Yes,
45.
yes. And you didn't get my response.
Oh, let me, can I just end this?
Yes, yes, yes.
Let me end it first.